For this video, we are going to discuss Article 156 of the Revised Penal Code, which is the crime of delivering prisoners from jail. Article 156, delivering prisoners from jail. The penalty of arresto mayor in its maximum period to prisión correccional in its minimum period shall be imposed upon any person who shall remove from any jail or penal establishment any person confined therein, or shall help the escape of such person by means of violence, intimidation, or bribery. If other means are used, the penalty of arresto mayor shall be imposed. If the escape of the prisoner shall take place outside of said establishments by taking the guards by surprise, the same penalties shall be imposed in their minimum period. These are the elements of the crime of delivering prisoners from jail. First element, that there is a person confined in a jail or penal establishment. And second element, that the offender removes therefrom such person or helps the escape of such person. Now, let us treat each one of these elements in this slide and in the succeeding slides. So, let me read to you again the first element, that there is a person confined in a jail or penal establishment. The person here being referred to in the first element may be a detention prisoner or a prisoner convicted by final judgment or serving sentence by final judgment. When you say detention prisoner, this refers to a person who is accused of a crime and who is temporarily confined in a jail or penal establishment while his case is pending or is not yet terminated. Now, when you talk about a prisoner convicted by final judgment, this refers to a person who has been convicted and his conviction is already final. Meaning to say, he has lost the opportunity to appeal his case, or he may have appealed his case, but the higher court before whom his case was appealed affirmed the decision of the lower court. Now, when you say jail or penal establishment, this refers to any lock-up cell in every police station or any jail managed by the Bureau of Jail Management and Penology or any jail managed by the LGU concerned or any jail managed by the Bureau of Corrections. Now, this term, jail or penal establishment, extends to hospitals or asylums where the prisoner is temporarily confined. Second element, that the offender removes therefrom such person or helps the escape of such person. The offender here is any person who must not be a custodian of the prisoner. When you say custodian, he refers to the public officer like the policeman in charge or the jail guard in charge having custody of such prisoner. Now, if the custodian himself connived in the escape of the prisoner or the latter escapes through his negligence, such custodian will be liable not for the crime of delivering prisoners from jail, but for the crime of infidelity in the custody of prisoners, either under Articles 223 or 224 of the Revised Penal Code. Thus, the offender in the crime of delivering prisoners from jail can be an outsider, or he may be a public officer or employee who does not have custody or charge of the prisoner, like the clerk inside the penal establishment, who doesn't have custody of the prisoner who escaped. Or the offender could be a fellow prisoner himself who helps in the escape of the said prisoner. Or the offender could be the policeman or jail guard in charge who is at the time of the escape off duty. Meaning to say there is another policeman or jail guard in charge who took over the custody of the prisoner who escaped. And the policeman or the jail guard who was off duty was the person who removed from the penal establishment such prisoner, or he was the person who helped the escape of the said prisoner. Take note that the removal or the assistance rendered does not have to be by means of violence or intimidation or bribery. Other means may be used. Also, take note that the means used is not an element of the crime. As I have already explained, there are only two elements for purposes of the crime of delivering prisoners from jail. The means used is only important when we take into consideration the penalty to be imposed, because if the removal or the assistance rendered is by means of violence, intimidation, or bribery, the penalty is higher. And if the removal or the assistance rendered is through other means, the penalty is lower. What about the second paragraph of Article 156? If the escape of the prisoner shall take place outside of said establishments by taking the guards by surprise, the same penalties shall be imposed in their minimum period. For this paragraph to apply, the removal or the assistance rendered must take place outside of the jail or penal establishment. And although it would seem that in this second paragraph, there is only one means used in helping the prisoner escape, which is by way of taking the guards by surprise, I would venture to theorize that the escape of the prisoner or the assistance rendered to the prisoner who escapes can be done through other means. It can be done through violence, intimidation, or bribery. It doesn't have to be limited by taking the guards by surprise. Although it would seem that way, that the second paragraph only mentions one way of helping or assisting the prisoner in his escape. That is by taking the guards by surprise. Question: what about the prisoner whose escape was made possible due to the commission of the crime of delivering prisoners from jail? Is such prisoner who escapes criminally liable? The answer is, it depends. Why? Because if the prisoner is a mere detention prisoner, then such prisoner is not criminally liable. Why is he not criminally liable? Because there is no provision in the Revised Penal Code nor in Special Penal Law punishing a detention prisoner who escapes. But if the prisoner is a convict by final judgment, then this time he will be liable for the crime of evasion of service of sentence under Articles 157 or 158 of the Revised Penal Code.